Welcome. It's 10 degrees at 5 a.m. Central Milwaukee time, Chicago time, noon Central European time, 7 p.m. in Beijing, and I hope you're enjoying your midnight snack in Australia. My name is Robert Meisey. Welcome to this series for U.S. legal issues for foreign businesses in the United States, presented by Reinhart, Berner, Van Duren. We're based in offices in Chicago, Milwaukee, Phoenix, Denver, and others. This morning, our program is U.S. corporate issues for foreign businesses in the United States. We welcome questions, and we'll try and answer as many as we can at the end of the program. To the extent that we can't answer them all within the hour, we'll try to answer them offline. Now, let me introduce my colleague and partner, Adam Konrad. Adam is a graduate of the University of Wisconsin, and he attended law school at Cornell University, where he received both his JD degree and his master's in international law. Adam has been with the firm since the summer of 2004. He's in our corporate department, and let me say this. I like to think of Adam as the consummate international business attorney. Not only does Adam understand the corporate legal issues relevant to properly advise clients, but he also has a strong background in international tax issues, which is very helpful when it comes to structuring operations in the U.S. for clients. Adam, audience is yours.
Thank you, Rob. And thanks everyone for taking the time out of their schedules to attend this program today. We're going to cover a number of topics here that relate to corporate issues as I just tee up the right slide. And I figured the best way of doing it was posing questions and trying to answer them, sort of the same questions that we often see when we deal with clients that are coming to the U.S. The first question, probably more background than anything else, is what are the relevant sources of law? What are you dealing with when you're trying to enter the U.S., and what do you need to be aware of, and where do those laws come from? The next question would be, how might my clients enter the U.S., and then what types of business entities are available in the U.S.? After that, we'll talk about what restrictions exist with respect to non-U.S. ownership of U.S. businesses and what U.S. regulatory regimes your clients should be aware of. So first, what are relevant sources of law in the U.S.? I get the slide to go. Oh, wait a second for that. The U.S. system is a constitution-based federal republic, which means that we have, in theory, limited federal government and then 50 separate state governments. So one thing that clients don't always consider when they're coming to the U.S. is that they're not just dealing with the U.S. government as a whole, but rather that there's also separate state levels of government as well as local levels that they're going to have to work around. We have at the federal level at least something called separation of powers, which I'm sure many of you have heard of. That means that we try to divide government into three branches: the executive, which is the president, and administrative agencies like the EPA, the IRS. We also have the legislative, which in the United States is divided into two houses: Congress, the House of Representatives, and the Senate. And then finally, the judiciary, which at the federal level is comprised of the Supreme Court at the very top. We have one Supreme Court, as well as then federal courts of first instance and federal appellate courts that are divided into regional circuits. Finally, one thing to note against the entire background of this is that our system is common law based as opposed to code based, which means that case law plays a significant role in determining how people are meant to interact and how laws are interpreted. And as a result, because of this decisional law basis, our court decisions tend to be relatively long, and they tend to, under the principle of stare decisis, remain in effect for very long periods of time, which may lead to some bizarre results. That against the background of the fact that we have, at least at the federal level, separate circuits can mean that you have different rules applying in different regions of the country, which can be confusing, to say the least, for foreign investors and foreign businesses coming into the U.S. Looking at the federal sources of law, go back a bit. We have a couple of key sources: the Constitution, which is the law of the land. That is our primary document. It's probably only about 10 pages long, and it's relatively easy to read, but probably very difficult to derive any meaning from the plain text of. Then we have statutes and treaties. The statutes are promulgated by the legislature, generally signed into law by the president, and then also treaties, which follow a somewhat similar process. And in contrast to other jurisdictions in the world, statutes and treaties are placed on the same level. So whereas, say, in another jurisdiction, in most other jurisdictions, treaties will rank above statutes in terms of deciding how to resolve a legal dispute. In the United States, the treaty is not accorded any more importance than a statute. In fact, there's a last-in-time rule which says that effectively U.S. Congress can override its treaty obligations by simply passing a law that would allow it to do so. In most cases, courts will try to read the treaty and the statute in such a way as to avoid that type of override, because obviously we would lose a lot of credibility in the world if our Congress was constantly overriding treaty obligations. But it is something to note that the treaties generally are not given any greater weight than the statutes. One side note to all of this are executive orders. Some of you may have taken note of the fact that President Obama noted that he would be willing to work sort of around Congress and promulgate more executive orders. These are effectively statutes or laws, if you will, that come directly from the executive. Historically, the area where I've seen them the most has come up in programs administered by the Office of Foreign Assets Control, where the president effectively declares certain individuals or certain regimes as unworkable with the U.S. and prohibits trade with those groups. But executive orders may provide an avenue for the executive to take action without having to work through Congress, which, if you have a Congress that's as gridlocked as ours, may move things forward a bit. The next level of sources of law will be regulations. These typically come, again, from the executive, but they are intended to interpret the statutes that have been promulgated typically by Congress. Regulations will have varying weight depending on their content and also the manner in which they're promulgated, but they tend to be the next best place to get additional guidance or detail as to what the law is intended to say or what the outcomes under the law are intended to be. Challenging a regulation, for example, challenging a Treasury regulation, which would be a regulation dealing with our tax laws, can be a real uphill battle, even though sometimes those regulations may appear to extend beyond what is permitted in the authorizing statute. So you'll have the statute. The statute might provide basic rules about how a particular situation is to be addressed, and then the regulation will go into sometimes painstaking detail as to the mechanics of addressing those situations. And again, the regulations tend to be the first and best source for guidance on how to interpret and address the statutes. There's other administrative guidance as well. Again, coming back to tax, you have revenue rulings, so rulings that will be binding on the tax authority because they're made publicly available, sort of like regulations, but typically given less weight. You have administrative guidance that's given less weight. For example, private letter rulings, again in the tax context, where an individual taxpayer will go to the tax authority and try to get a particular issue decided in its favor. And although those are published and made available generally, they do not contain the details, particular facts that relate to an individual taxpayer, and typically you're not permitted to rely on those, say, in court to the same extent that you'd be able to rely on a revenue ruling or a regulation. Finally, because we're a common law jurisdiction, court rulings play a significant role in how our laws are interpreted. Again, I mentioned that we have federal courts and state courts. At the federal level, you'll have court rulings at the district court level, which is our courts of first instance. Those can go up to an appellate court at the circuit court level, and then finally, in some limited circumstances, cases may be appealed to the Supreme Court. The final source of law, which I think is largely overlooked in typical discussions of what sources of law are contracts. Obviously, contracts tend to be private affairs between the parties to the contract. However, in many contexts, for example, mergers and acquisitions, and even dealing with other contractual issues when working with public companies, you'll find a number of contracts that have been disclosed, made publicly available, and they can provide a sense as to what the market on terms may be. Or you might find treatises that will compile statistically certain deal points in contracts. For example, the ABA has a study that comes out every couple of years that will go through maybe the top 30 or 40 deal points and give negotiators a sense as to what may or may not be market for a given size of deal in a given industry. Those are the federal sources of law. The state sources are, again, relatively similar. In fact, the best way of thinking of the state at the state level is generally it will mirror the federal government in terms of the organs of government. Each state can be different. We have 50 separate states and the District of Columbia. And the idiosyncrasies of each regime can be confusing, to say the least, but typically your states will have a constitution. Most states will also have, in fact, all states will have statutes. States cannot enter into treaties. That is the purview of the federal government. States will typically have some sort of administrative guidance or regulations as well. In contrast to the regulations at the federal level, which number, I want to say, in the tens of thousands of pages easily, the state-level regulations are probably significantly shorter. In many cases, you'll find state-level regulations that will incorporate by reference federal provisions, simply making it easier for businesses to say, okay, if I'm in compliance with the federal set of rules, I know I have to be in compliance with the state set of rules. There's also other administrative guidance at the state level. Depending on what sort of branch of government you're dealing with, you might be looking at rulings, it might be informal letters from state actors, such as the Attorney General, that can provide guidance as well. There are state courts, and state courts are of general jurisdiction. So most disputes will be resolved or at least heard first in a state-level court, and those state courts then will typically have an appellate level as well as a state court level through which disputes can be appealed. There are probably treatises and textbooks and whole cases in law school that can discuss the dance between having your dispute heard in state court or federal court and when is it appropriate to remove the dispute to federal court, which is why oftentimes in dealing with contractual provisions, you'll see in the venue clauses inclusive language that refers to both, say, the state and federal courts of California or the state and federal courts of Illinois, depending on typically which jurisdiction is most convenient travel-wise for the party, as opposed to perhaps where the laws may be most favorable. And then finally, obviously, contracts provide guidance as well as to what might be expected of people in different states. Different practices may apply in different states. So one that comes to mind would be non-competes and their enforceability. Wisconsin tends to be a jurisdiction that views non-competes and covenants not to solicit, not to hire with some skepticism. In fact, it's one of the, at least anecdotally, most difficult jurisdictions to have such provisions stand up and be respected by a court. Other states take other approaches. California, for the most part, will try to prohibit non-competes outright. Oregon has a statute that takes a similar approach, but some states can be much more friendly to the concept of post-termination non-competes or sale of business non-competes, and will impose fewer restrictions, or if the restrictions are overbroad, instead of simply striking out the provision, this might happen in some jurisdictions, might allow the court to quote-unquote blue pencil it, so to revise it to most closely reflect the intent of the parties, while at the same time being within the bounds of the law. So that's a quick overview on the state and federal sources of law. A couple of notes as to how our system may contrast with other jurisdictions. Obviously, I mentioned treaties generally are not subordinate to statutes. Treaties are generally not superior to statutes. They're generally on par with statutes with a last-in-time rule. We have a role here in the U.S. of regulatory guidance that I think is greater than certain jurisdictions, such as, say, Germany, where commentators may play a much greater role in providing guidance and interpretation of what a statute says. There is no federal corporate law, which I think can be somewhat confusing. We have 50 states, which means that we have 50 separate state corporate law statutes. Fortunately, there are trends. There's the Model Business Corporation Act, which a number of states subscribe to in some form. We also have the Delaware General Corporation Law, which a lot of states have patterned their laws after, particularly, say, Nevada. And then there are other statutes that over the years have been promulgated either as model laws or just been picked up. Examples that come to mind, LLC statutes, Uniform Fraudulent Transfer Act, Uniform Limited Partnership Act, those types of statutes which hopefully lend some standardization across jurisdictions so that you have some comfort that if you set up, say, a company in Delaware and you want to have a factory in New Hampshire, or you want to have a deal with companies in New Jersey, that you're dealing with them on a basis where your company will be respected, presumably by qualifying to do business in those foreign jurisdictions. And members, so investors, don't need all to come out of Delaware to understand what their rights are. They can look at the statute, they can understand the statute, and perhaps if they have investments in other entities throughout the country, the concepts of fiduciary duties, of governance, voting, those types of things will be somewhat familiar to them. Now that said, those statutes are not all the same, and you can definitely run up against distinctions between the different jurisdictions, for example, between the Model Business Corporation Act and the Delaware General Corporation Law. Finally, well, I mentioned the diversions to courts. Again, for example, Wisconsin, you may have a provision that is simply not respected in terms of non-compete, or non-disclosure obligations, typically with respect to their scope or their duration. You might go to a state like Illinois or Ohio, and the courts would have no problem enforcing those provisions. For the final contrast I'd like to point out is the dichotomy between the transactional litigation practice among attorneys. In the U.S., it's not uncommon to see someone, even early in law school, sort of veer in either one direction or the other. You might have a dalliance with moot court for, say, one semester or 1 year, but then afterwards you typically find your path as either being someone who wants to work on contracts, on deals, not going before a court, or someone who really enjoys speaking before a court and more adversarial litigation practice. I know that this is different than in some jurisdictions where you might have, say, the deal attorney is also responsible for litigating post-closing disputes, while I think in my personal experience there is some negotiation that may happen with respect to those disputes after the fact. Should something go to a court and actually progress to that level, and most of the time things don't get that far, most of the time parties settle, then you will want to bring in a litigator as well as say, specialists in areas like labor, if you're dealing with a real estate dispute, someone who's say, responsible for discussing title insurance issues, those sorts of things. So that's the capsule summary on the relevant sources of law. Move on to the next question. How might my clients enter the U.S.? There are a number of different avenues that foreign businesses can come into the U.S. So the simplest and most basic is probably direct sales. Usually the first toe in the water of the U.S. markets, kind of getting a feel for what it's like to sell to U.S. clients or customers. Next level might be through an agent or representative. You might see this when sales levels have stabilized to a level where it makes sense to have somebody there on the ground, drumming up business, managing customers, really making sure that your name is getting out there and that you're going to trade shows and that there's a familiar face for customers and potential customers to see and to interact with. The next level of engagement with the U.S. markets might be a distributor. This is a party who, in contrast to an agent or representative, will be responsible for purchasing, say, products and then reselling those products in the U.S. So while an agent may go into the U.S. and have authority to act on behalf of the foreign principal, sometimes in some limited cases even sign contracts on behalf of the foreign principal, that's not what a distributor does. A distributor purchases, say, product for its own account and then resells that product to third parties. So it's really another step in the distribution chain as opposed to being more of an extension, an advertising arm, a marketing arm of the principal. We've also got joint ventures up there that is, wedged in between distributor and branch and subsidiary, mainly because that's sort of where I see clients coming in. Maybe they've got an agent, maybe they've got a distributor, and they want to, say, move production to the U.S., or they want to have much more control, much more of a presence in the U.S. than they had previously with their agent or distributor. And oftentimes, the joint venture partner that they seek out may be that agent or distributor. That might be one type of joint venture. Another type may be an opportunity to engage in research and development to customize a product for the U.S. market, where someone like a distributor may have specialized knowledge that makes them valuable and would make them a good joint venture partner in terms of helping bring those products more fully into the U.S. market. Finally, the last step I typically see is with a branch or subsidiary. So this is where the foreign business brings production over, or if not that, maybe distribution, but does everything in-house. So there's no need for external help here. They want 100% control, and they may do that through a branch, which really, for non-tax purposes, looks very similar to a subsidiary or a subsidiary. And in these cases, we're talking about typically a wholly owned entity of some form. With a branch, it may be something that is taxable as a flow-through entity. That's why we call it a branch. And with a subsidiary, it would be something that would probably take the form of a corporation as viewed by the IRS. So it would be separately taxable in the U.S. as a corporation. I'm going to go through each of these now in a bit more detail, just to flesh them out. Direct sales, as I mentioned, often the simplest alternative and usually the first foray into the U.S. market. Typically, these start where your client may get an inquiry from a U.S. customer saying, I'd like to buy some of your product. Would you mind shipping it to Connecticut? And oftentimes those first few sales are sort of a fire drill in trying to get the product in. If you haven't done a lot of exporting or exporting to the U.S., perhaps there are some corners that are cut in terms of getting the goods over and dealing with export compliance issues. Oftentimes we've seen clients that will try to come into the U.S. selling on their non-U.S. terms and conditions. So they have probably a set of terms and conditions of sale that they've developed for European markets, for Asian markets. And if the customer is, really red-hot eager to get their hands on your products, it probably won't scrutinize those terms and conditions that much, or maybe you'll have what's called colloquially in the U.S. the battle of the forms, where the customer will keep sending purchase orders or confirmations of confirmations, sort of have the last word in terms of sales documentation. In any event, direct sales typically tend to be the first way that a customer will come into the U.S. And like I was mentioning, it's important with those direct sales to address things like delivery terms, governing law, title passage, and rethink terms and conditions that you might not need to rethink if you were selling, say, purely in your home country or to the export markets that you're usually dealing with. Some unique issues on these. On delivery terms, U.S. customers tend to not be the most well-versed in the Incoterms. Because we have such a broad domestic market, most of the time customers are probably buying from somebody who's also in the U.S. And to add to some of the confusion, each of the 50 states' laws has its own sales law. Fortunately, in many cases, they will have adopted some form of the Uniform Commercial Code, which is sort of our uniform domestic sales law. But that Uniform Commercial Code provides things that look and sound a lot like Incoterms, like FOB and FAS, but they are not the Incoterms. And in fact, the incarnation of the Uniform Commercial Code in Wisconsin provides two very divergent meanings of FOB. So what we often advise our clients who are coming into Wisconsin, or our clients who are going out of Wisconsin, and other clients who are coming into other jurisdictions is have a look at the state law delivery terms, understand what they say, but 9 times out of 10 you will want to sell on Incoterms. Everyone seems to understand, at least outside the U.S., what Incoterms mean. Figuring out sort of the general contours of what an Incoterm is meant to capture, who is responsible for import and export compliance, who is responsible for packaging the goods, for loading the goods. That's all provided largely by the Incoterms, and using Incoterms is probably the best way to proceed as opposed to just simply referring to FOB. The other thing is, if you're referring to an Incoterm, make sure that your sales terms reference the Incoterms. So don't simply say FOB, because that could be interpreted as being state law, but refer to FOB Incoterms 2010. Important also is to reference the governing law. Many times, I think this is omitted, at least in purely domestic contracts, because parties may not feel that they need to do so, or perhaps they simply forget to send the second page of their terms and conditions and just scan the backside of the purchase order. But governing law is key, particularly when you're dealing with 50 different sets of governing laws. So in your sales terms and conditions, have a governing law clause. Make sure that the governing law clause disclaims operation of conflicts of law principles, which is another sort of rat's nest of figuring out whose governing law applies. And then importantly, because the U.S. is a party like a number of other countries to the UN Convention for the International Sale of Goods, importantly exclude expressly the operation of that convention. I'm sure many of the folks on the call are aware, if you don't expressly exclude the operation of the CISG, the CISG applies, notwithstanding the fact that you may have a governing law clause that says, this contract is governed by New York law without regard to conflicts of law principles. If the contract doesn't say anything more than that, you're probably going to be having to face arguments that the CISG in fact does apply, when in most cases you don't want the CISG to apply. You will want either your local sales law to apply, or it would be perfectly reasonable to expect some form of a UCC. So the Illinois UCC, the New York UCC, Uniform Commercial Code is what I mean by UCC, which is the sales law standard that is more or less adopted by every state in the country. It's important to deal with import rules and import compliance. If you haven't engaged an individual who is qualified to act as a customs broker in the U.S., and that is a separate qualification, sort of like a tax advisor in Germany, a customs broker is someone that has sat for an exam and should know the import and export rules fairly well. You'll want to talk to someone because there is some complexity in getting goods imported into the U.S. Sort of ancillary to that, the goods must be properly marked. So obviously, if a good is made in China and doesn't undergo any sort of further manufacture or transformation in the United States, it will need to be stamped made in China. Oftentimes, people will try to get around that because things look better. At least it's presumed that products may be more attractive to U.S. buyers if those products can be stamped made in the USA, which is why, if you flip over your iPhone, you'll probably see something to the effect of designed in California, assembled in China, which is sort of Apple's nod at trying to pull as much of that U.S. spirit into their product as they can. Note that it's important, though, to at the very least comply with the marketing designations. Certain countries, products of certain countries that might be viewed as more attractive to U.S. customers, you may want to leave the foreign name stamped on there because that may be something that lends some prestige to the product. But at the very least, marketing rules need to be considered. And then finally, sort of the key written agreement that will govern direct sales are the terms and conditions, that purchase order, usually with terms and conditions attached to it. Again, it's best to have terms and conditions that you've specifically developed for the U.S. market, and it's important that they are actually used. So as much as I can talk myself blue in the face to clients about this and even prepare terms and conditions for them or revise their terms and conditions, the message needs to filter down to the people responsible for the sale that those terms and conditions are actually sent to and ultimately signed off on by your contractual counterparties. So those are direct sales. Now moving on to agents and representatives. An agent is where a client appoints a third party to take actions on its behalf in the U.S. This delegation of authority naturally can create some risk, so it's necessary to limit that authority and to police those limits given the apparent authority issues. Principle of apparent authority, which I'm guessing applies in many foreign jurisdictions as well, is that if an agent appears to third parties to have authority to act on behalf of the principal, and those parties rely on that apparent authority, the principal can in fact be bound by the actions of the agent. So what this can mean is that you need not only to say in your contracts that specifically delineate in your contracts what the agents may and may not do on your behalf, but you need to make sure that there's some policing going on so that if there's ever confusion about what the agent may or may not do or has authority to do, you can at least go to the third party and say, look, it's somewhat of a defense. He had no authority to act on our behalf. We had no idea that he was acting on our behalf in this manner. And that's really the crux of that issue. The key written agreement in the agency context is some sort of agency agreement or representative agreement. Because of U.S. tax issues, and my colleague Rob will get to that in a later session, we often blanket these types of agreements with the phrase independent agent. So instead of saying simply sales representative agreement or agency agreement, it'll say independent agent agreement. And every time in the contract you refer to the sales representative or the sales agent, that term is replaced with the phrase independent agent. The reason for doing so is to underscore to everybody, and particularly the IRS, if the contract falls into their hands in connection with an audit, that this agent is viewed by the parties as being completely separate and independent, and hopefully, therefore, not creating a permanent establishment on behalf of the principal in the U.S. Let's see what else. Compensation on agency arrangements often takes the form of a commission on sales. There are a lot of moving parts on this, and lawyers will, in my experience, often punt and sort of let the clients write out their own commission arrangement, often to an exhibit. Some issues I think that often get overlooked by clients are how the commission is calculated. So are we dealing with gross numbers versus net numbers? And whether or not there is an offset for refunds, chargebacks, returns. If those types of issues aren't addressed in your commission arrangement, you may be unpleasantly surprised if your agent says, all right, I sold $1 million worth of products, and I'm entitled to a 10% commission, so send me $100,000, when in fact, $1 million worth of products took into account, say, $50,000 worth of costs in getting the product over there. $200,000 of the product was returned within a couple of weeks. So making sure that the agent is not paid for sales that they don't stick is critical, and oftentimes I think clients overlook this. Usually it just takes one good or one bad experience with them being burned, or one good contract where they can go back over and over again to that agency agreement, and they're usually set. Other things that play into the calculation of commission can be a need to hit certain minimums each year, particularly if your agent has been granted any sort of exclusivity with respect to a particular geographic region or customer market. And another issue that might crop up is sort of the flow of funds. As the agent, I would want the customer to pay me so that I would then remit anything net of my commission onto the principal. This creates a whole bunch of problems for U.S. tax reasons. So the way that we typically want to structure this is to have the customer pay the principal directly, because again, it is the principal that has the contractual relationship with the customer, not the agent. And then the principal will remit money, the commission, down to the agent once those sales have stuck. Finally, if you're dealing with a savvy agent, so an agent that has represented a number of other principals in the past, or is really going to scrutinize a contract, it won't be surprising if they want to audit the calculation of the commissions. And oftentimes, as a principal, you may be fine with this. You may say, okay, it would look like we're operating in bad faith if we don't allow the agent to come in and at least have some level of insight into how we're figuring these commissions. However, it's important to sort of balance that against what would make sense, and not let the audit sort of carry away the relationship. So what we typically tend to do is limit the number of times per year that the audit can be conducted, as well as require the agent to bear certain costs unless it discloses a disparity in excess of 10% of what it should have been paid and what it was paid. I mentioned exclusivity earlier. Agents will often want exclusive rights because they're going to be engaging in some efforts to drum up a client base, and they'll feel probably cheated or shortchanged if they're not getting the full benefit of the market that they were granted. Again, we would recommend making that exclusivity contingent on hitting certain minimums. It's not unreasonable to also, the agent asks for exclusivity to require the agent to be exclusive with respect to representing your kind of product. So if you sell, say, agricultural knives, you don't want the agent going around and selling your competitors' products as well, because there's probably a limited number of customers out there, and it would be kind of weird for the agent to show up, sort of open up its coat and say, I have product A and product B. Which one can I interest you in more? The agent would make a commission on either sale, so its incentive is to get to a deal as quickly as possible, rather than sort of representing the interest of the principal, which might be sticking firm on things like price and term. Two final points on agents. You have this concept in U.S. tax treaties as to whether an agent is dependent or independent. If you're dealing with a treaty jurisdiction and the concept of permanent establishment, this can be quite relevant, because if you can avoid having a permanent establishment, and there's no reason why most agency relationships can be structured in a manner that avoids creating a permanent establishment, you will want to, because it means fewer tax reporting and withholding obligations with respect to your U.S. activities. You want to set up the agent as independent as possible, and this means papering the relationship in such a way so that the agent looks like they're acting on your behalf, on the principal's behalf, but they are, in fact, economically independent of the principal as much as possible. And finally, the agency agreement should address rights upon termination. In contrast to a number of other jurisdictions, there's typically not a need for a one-out commission to be paid. So, for example, if the principal terminates the agent, there's, generally speaking, no requirement that the principal continue to pay the agent sales within the territory, or to have to buy back the book of customers that the agent has generated. All of that can be, generally speaking, regulated by contract. There are some state-specific statutes. They often refer more to distributors than agents that can influence this, but for the most part, you're able to write your own rules into what the consequences of terminating the agent can be. And obviously, we recommend making sure that things like making the agent return any confidential information, making sure the agent ceases acting on your behalf are baked into your contract, because there are no statutes that would govern that termination, and the contract is really what sets the rules for what happens to the agent after it's terminated. Next area, and I'll move a little bit quicker now, is the distributor. The distributor, like I mentioned, in contrast to agents, takes title to product and resells for its own account. So here, the distributor is really your first-line customer, and you may feel that you somewhat absolve yourself of responsibility for dealing with the customer because you sold it to the distributor. The problem is the distributor functions much in the same way as an agent in being your face in the United States. So it's still important to impose restrictions on what the distributor may and may not do in the U.S. Because you certainly don't want them reselling your product at a loss, selling your products in such a way that might impose liability on you. For example, giving reps and warranties about the products and their technical characteristics that are wildly inaccurate just in order to unload the product. The issue here is, not necessarily that at the end of the day, a lawsuit by that customer would succeed against the principal or the primary seller, but rather that the principal would even get dragged into a lawsuit. The practice here in the U.S. is if something goes wrong, you file a lawsuit and you name everybody possible in the chain. So from the distributor all the way up to the manufacturer, and sometimes even the manufacturer's suppliers. What this means is that you want to restrict the distributor from saying anything about the product that is inconsistent with what, say, you might say to a potential customer about the product. You might want to restrict the distributor from giving any sort of warranty about the product in excess of what you're willing to provide. And you might want to make sure that the distributor sort of markets those products in a manner consistent with how they're marketed back home, because, again, the distributor is your face in the U.S. The key written agreement in this context is a distributor agreement. It will have a lot of similarity, in many cases, to an agency agreement. Sometimes we even sort of see hybrid arrangements where a party is apt to act as a distributor in certain markets and as an agent in others. So it's not uncommon to see a lot of overlap between the two. But just understand that conceptually, an agent does not purchase the principal's products and resell them, whereas the distributor does. Compensation also differs in the distributor context. The way that I typically see it is a discount from standard pricing. So a distributor will be able to purchase products on slightly more favorable terms, usually not commercial terms, pricing terms, and then how the distributor is compensated is basically a function of how it's able to sell products at the price that it would typically charge over the discount that it purchased them from the principal from. Again, like an agency relationship, a distributor relationship should address rights on termination. Here in this context, you do see oftentimes statutes that will come in and provide a little bit more of a framework as to how the distributor ought to be treated. Certain types of products, and these statutes tend to be capsule and product lines, certain types of products won't have any sorts of restrictions, but if your client is selling outdoor power equipment, which can be vehicles, four-wheel ATVs, can be farm equipment, can be agricultural equipment, can be generators, and this is, again, state by state. If they're selling those types of products, and sometimes the statutes are even generally applicable depending on the state you're dealing with, you may have a very regimented rule as to how you can terminate the distributor, modify the distribution arrangement. So there may be restrictions on the parties, say, amending the agreement down the road to remove exclusivity, to restrict the territory, to even add to the territory. Can sometimes be a hurdle that needs to be jumped through in dealing with the statute. So something to be aware of there, that your contract may not be the last word when dealing with a distributor, and also in some cases with agents. We have a group of about, I want to say, 8 attorneys here that works almost exclusively with product liability and also product distribution type issues. and have developed some knowledge in looking at each of these state statutes and understanding what they say. Fortunately, the Wisconsin fair dealership law, which is pretty stringent, has turned out to be the model for a number of states. So again, like with the corporate and partnership and fraudulent transfer statutes, you see some trends, but in any event, you're going to need to look at specific cases or specific statutes, and then also taking a step further, looking at cases that interpret those statutes. Next step, and I'll speak only briefly about joint ventures, is the joint venture. As I mentioned before, these have typically a lot of moving parts. You're dealing often not only with sort of the governance issues of, say, having an entity that would be created or a contract that has sort of input and governance issues baked into it, but there is also probably some sort of licensing or leasing or other ancillary arrangements that need to be negotiated. And these typically are designed sort of like a, if you will, a prenuptial agreement with a pre-negotiated divorce, and if in the case of IP-intensive joint ventures, pre-negotiated child custody settlements. So these, in their best form, are probably built to break, and a lot of attention will be spent and given to making sure that the buy-sell provisions or the termination provisions are workable, because typically a joint venture is seen as sort of a temporary step, at least for the foreign party, in coming into the U.S. and really establishing a more permanent wholly owned presence in the U.S. These can be, as I mentioned, purely contractual, which may be fine. And in some cases, if they are going to be purely contractual, you might go back to the client and say, does a joint venture really capture what we intend, or is this really an agency or distribution relationship with licenses on the side, maybe warehousing space? Or the other type of joint venture may involve a jointly owned entity, and that obviously carries with it its own set of questions. Joint ventures tend to also be driven by a business plan. In my experience, the clients will pay a lot of attention to the general terms of the joint venture, and no matter how many times you can sort of drill into them, the importance of getting that business plan put together, that's usually the last thing to come together, either at the closing of the joint venture or even in some cases afterwards. If I had one thing that I would advise clients going into a joint venture, one piece of advice to pass along, it would be to put the development of the business plan at the forefront and really budget out, develop a budget for the next 12 to 18 months, develop the targets, which will be sort of go or no-go type targets in terms of whether to proceed with the joint venture, to keep putting money into it, to keep even running it, as opposed to waiting for all the other documentation to be put together. Because without having the business plan, the joint venture doesn't make sense. It's going to be the business plan that drives things going forward. The joint venture agreement is really just a framework for dealing with governance issues, resolving disputes and deadlocks, and addressing the buy-sell, which often has been triggered unless if you have an issue under the business plan. Finally, talk briefly about branch or wholly owned subsidiary. The distinction here is more relevant for tax purposes than anything else, but this is a wholly owned entity. And if you're going to set one of these up, and we'll talk about some of those issues next, one thing that I think gets overlooked is sort of the raft of contracts and terms and conditions and other sort of U.S. relationships that need to be developed when putting together a wholly owned entity. It's not as simple as calling up your attorney in the U.S. saying, go ahead and form a corporation on my behalf. You need to think about who's going to be physically there working in its offices, if you're going to have anyone, how that corporation is going to do business with clients. Oftentimes we see clients come in and simply assume that they'll use their home country terms and conditions, even sometimes their foreign language home country terms and conditions when selling to U.S. customers. And really, if you haven't gotten to the level where you have developed sort of English language, U.S. appropriate terms and conditions, sales contracts, employment agreements in particular, if you're going to have people that you're going to give employment agreements to, maybe you're not ready to have to set up a branch or a subsidiary, or at least those need to be part of that project in terms of getting that put together. I've acted on behalf of a number of German companies that have come to the U.S., and one thing that has struck me consistently with nearly all of them is that they invested in the U.S. subsidiary. However, they did not invest in sort of American-style employment agreements. So you had these German language employment contracts that probably, while totally appropriate for the German market contain terms with respect to, say, vacation, non-competition clauses, notice on termination that would be completely inappropriate for the U.S. market, which I think is a lot less favorable to U.S. employees, even the types of employees that ultimately do get written employment contracts, few and far in between, than what you might see outside the U.S. So definitely, before simply assuming you can import those agreements and those terms and conditions, talk with your U.S. counsel, and maybe they'll have a different take on things that would be even more favorable than you might have expected. I'm going to move on now, a little bit quicker, to talk about types of business entities that are available in the U.S. And they are corporations, limited liability companies, partnerships, and sole proprietorships. I will cross sole proprietorships off the list almost immediately because, in contrast to other jurisdictions, nobody here does business as a sole proprietorship. The cost of setting up a wholly owned entity is so low, and when it comes to a limited liability company, disregarded for tax purposes, there's just simply no sense in doing business as a sole proprietorship. So again, whereas in other jurisdictions, you may have business actors who will act as sole proprietors, even with relatively large companies or entities, businesses. You do not ever see that in the U.S., and everybody operating domestically is operating behind some sort of legal entity. Corporations, probably the most common when we're dealing with foreign businesses that come into the U.S. Limited liabilities, less common, but definitely the second most common, and probably one of the most common forms of entities used within the U.S. Partnerships, in my experience, I don't see them so frequently, in part because foreign businesses coming to the U.S. usually want a wholly owned entity, and the mechanics of setting up a partnership is a wholly owned entity, and it is possible to do so with sort of a dummy partner. If you're going through all of that, usually there's a tax reason for doing so, and dealing with taking advantage of a treaty in a foreign tax regime. They won't recognize a limited liability company, but they will recognize a partnership. But 9 times out of 10, the types of entities that we're seeing are either a corporation or a limited liability company. And in both cases, they can be treated as corporations by the IRS. In only the case of a limited liability company do you have the flexibility to have it treated as a flow-through entity for tax purposes. I will talk exclusively about U.S. tax issues when I talk about tax here. Rob will talk about this in greater detail at a later session, but understand that obviously the other side of the coin is what the foreign tax consequences of your structure may be, and that can play just as important, if not a more important role, in deciding what type of entity and how you want to be treated for your tax purposes. General characteristics with respect to all types of entities, so corporations, limited liability companies, and for the most part, to partnerships. Address things like limited liability, the minimum number of required owners, minimum initial capital, the time required to form them, flexibility in using them in operations, size and turnover rules, and access to public debt markets. Generally speaking, corporations, limited liability companies, limited liability is provided to all the owners. With partnerships, if you're dealing with a limited partnership or one of its variants, limited liability would be provided to limited partners but not the general partners. Entities, corporations, partnerships may have a single owner. As I mentioned before, it's possible to structure a partnership so that it just has a single owner, practically speaking, although in a very rote sense it will have more than one owner. There are no minimum initial capital requirements, generally speaking, in the U.S. This is in contrast to a number of other jurisdictions where you may have to pony up 25,000 euro, 50,000 euro, 100,000 euro in order to set up the entity. That said, there is always a concern about veil piercing on the back end. So what we will see with clients that set up U.S. companies is that they will put some amount of money in the company, and that they will make sure that it's adequately capitalized to avoid sort of veil piercing concerns. The time to form entities varies by jurisdiction. Delaware will get you an entity within less than an hour. Some states are a little bit more pokey than others, and they can take several days. There are, generally speaking, no size or turnover requirements for any type of entity. So you can have publicly traded limited liability companies, publicly traded partnerships. Most of the time, publicly traded entities will be corporations, but any type of entity form is generally going to be okay. For any size of business operation, it's really going to be driven more by what makes the most sense for the foreign business, foreign investor. And then finally, any entity may be used to access public equity and debt markets. Oftentimes, the driving force behind what type of entity to use relates more to its tax characterization. Due to time concerns, I'm not get into that too much, but understand that it is a key factor, and usually the choice is between a corporation or a limited liability company. Because an LLC can be treated as a corporation if the foreign investor so elects, starting with a limited liability company may make sense, and treating it as a corporation afterwards. However, many times our foreign investors want to come in and just use a corporation because they know from the outset that that will make the most sense and maybe the easiest in terms of explaining their structure to foreign tax authorities. I'm going to talk a bit now about what types of restrictions may apply to the ownership of U.S. businesses. Aviation is one. Domestic air carriage is limited to U.S. registered aircraft. There are certain exemptions, but generally speaking, you need to have U.S. ownership or majority of U.S. ownership when dealing with domestic air carriage. Maritime shipping and fishing, somewhat similar. So coastal and freshwater shipping in the U.S. is restricted to vessels that are built and registered in the U.S. and owned by U.S. persons. Which could be presumably some type of U.S. entity, but again, be aware, like with the aviation rules, you may have to punch through and look at who the owners of that entity are. Banking is something that may also only be conducted in the U.S. With a government charter that has to be obtained from the U.S. comptroller of the currency, and all directors of national banks are required to be U.S. citizens. You also have federal and state rules, particularly if you're setting up like a trust company, which is another type of sort of federally chartered entity or state chartered entity. Telecommunications, I'm sure many of you are familiar with Rupert Murdoch, who nationalized, became a U.S. citizen in order to own Fox. He was previously Australian, so that is another area where U.S. ownership is critical. And then there are certain state restrictions on things like the ownership of agricultural or other types of land, typically over a certain threshold, not used for residential purposes. So your foreign businessman who wants to come in and buy a mansion in Rhode Island can do so. If he wants to buy a farm in Colorado, he may, a ranch in Colorado, he may have more issues. And then finally, CPS. And that's sort of an arbitrary black box into which transactions, so typically acquisitions or significant investments by foreign parties into businesses or industries that may impact national security may and probably should, if you're operating in that arena, be approved or signed off on by CPS. Historically, CPS has only blocked a couple of transactions, the most notable recent one probably being Dubai Ports World's proposed acquisition of a number of U.S. ports. Obviously, a lot of concern over having foreign persons controlling our ports, but definitely something to consider. And part of the risk with CPS is if you're subsequently determined to have engaged in acquisition of a company in an industry that it could impact national security, that transaction can be unwound by executive action. Finally, regulatory regimes that clients should be aware of, and I'm just going to tick through these because I think we're running short on time and I want to have some time for questions. Import rules, again, deal with the customs broker for that. Dealer-distributor laws, state-specific, very, in some cases, draconian statutes prescribing termination or other consequences if you do want to modify the terms of or terminate a distributor relationship. Restrictive covenants, we didn't get into this too much. It's not really a regulatory regime, but I did mention that certain states will respect covenants not to compete or covenants not to solicit or covenants not to hire more than others, and it's important to also understand how a court might react to them. Sometimes they may throw them out completely. Sometimes they may just modify them. The FCPA oftentimes may not be the first thing top of mind for foreign investors, but if they're doing things that are not FCPA compatible outside the U.S., the moment that they sort of set foot into the U.S. and become a U.S. actor in even the most attenuated way, that can create some FCPA risk, and it's usually a good idea to at least understand what the FCPA means. So definitely be aware of that. OFAC, Office of Foreign Assets Control, again, concerns about this really arise when you have someone entering the U.S., setting up, say, a U.S. subsidiary. All of a sudden that U.S. subsidiary has an affiliate totally outside the U.S. that does something incompatible with an OFAC program, for example, enters into a contract with parties in Sudan, does something in North Korea, et cetera. And because of the way that the OFAC rules are drafted, you do need to be a little bit worried about what that transaction may mean to your U.S. operations. The CPSC, if you're selling any type of consumer products, so these are products typically handled by consumers, bottle of water, this pen, my tie. These are all things that would probably need to be run through the CPSC in terms of getting some sort of certification. If it's a child product, which means that it's typically going to be used by somebody who's under the age of 12, there are additional hoops to jump through. And if you're dealing with alcohol, tobacco, firearms, boats, motor vehicles, ammunition, those types of products, it's not the CPSC that you go through in terms of getting your certifications and your compliance, but rather the specific government agencies. So, for example, if you're selling pharmaceuticals, you go through the FDA. If you're selling alcohol, tobacco, or firearms, you go through the ATF. But the CPSC is sort of your catch-all organization for consumer products, which again are products that are typically going to be used by consumers. If you're selling purely to business, if you're selling, say, agricultural knives, which are not going to say consumers, but rather to John Deere, then you're not really going to be dealing with the CPSC so much. But again, if you are, definitely an area of concern, particularly given how restrictive they can be with foreign created products. You have immigration rules. I mentioned them only in passing. We have a separate session. I think it's the next one that deals with immigration. The reason why this is important to at least have on your checklist is that if you are setting up a U.S. entity, you are probably going to be sending somebody down into the U.S. For a period of time to supervise, your local sales staff, to seek out, the warehouse where you can store your products, et cetera, and making sure that they come into the U.S. on the appropriate type of visa is key, so that you don't create headaches for yourself down the road. Finally, industry-specific rules. Sort of mentioned these when I went through the CPSC and terms of non-consumer products, so alcohol, tobacco, firearms, aircraft, boats, motor vehicles. All those things will have industry-specific regulations to worry about. And then finally, data protection. My final point. Outside of healthcare-related information, there's very little in terms of privacy law in the U.S., and in fact, in the last 9 months, very little privacy. So we do not have the privacy data protection directive type rules that are present in Europe. There is, however, a safe harbor program that U.S. companies, particularly U.S. subsidiaries and foreign entities, can sign up to become a part of, which can facilitate the flow of information between the foreign parent and the U.S. sub. So that said, I'm going to now turn it back to Rob, who's going to moderate questions in what little time we have left.
Okay. I've just been handed the questions that came in during the program. I don't know if I'll have a chance to answer all of them. To the extent that we can't answer all of them, Adam will answer them offline. So the first one, Adam, what factors should most influence the state in which I should establish a U.S. sub?
Well, I'd say that the primary factors are not, and we have a lot of clients that jump immediately to say, okay, I know what the federal tax rate is. I want to go to a state like Florida that doesn't have a state income tax rate, or one of the other 5 to 7 other states that have low or no state income tax rate. That's definitely part of the analysis, and there are consultants and accounting firms that can help identify what state tax regimes may be the most favorable. Somebody probably might have read a news story about Amazon strong-arming North Carolina into giving it a tax holiday in exchange for setting up a distribution center there. Most cases, however, state tax is not going to be the concern that drives where you set up the sub, particularly because you may not have income. In those initial years, you may really just be in a loss situation or a break-even situation trying to build up your client base. So what should drive it? The first thing I would say is logistics. Practically speaking, if you're selling products, you probably want to be near an area where you've got rail connections, highways, ports. Something like that would make probably the formation of that entity in that jurisdiction attractive, or at least setting up operations there. Because you can have an entity formed in one jurisdiction, but operations in another. Delaware Corporation, operations in New Jersey. California Corporation, operations in Texas. That's completely fine, and having the foreign, if you will, corporation qualified to do business in the state is not typically anything more than filing a form and paying an annual fee. So I would focus primarily on what practically makes the most sense in terms of reaching customers, maybe reaching suppliers, maybe having oversight over your customers or suppliers, and if you need to be close to any sort of R&D facilities, that too ought to go into it. But concerns like state tax, I would rank as secondary.
Okay. We have a few more questions, but we're running out of time, so Adam will answer these questions offline. I want to thank you for being with us. I want to remind you that our next program will be on Tuesday, March 25th. My partner, Ben Curtin, will talk about U.S. immigration issues for foreign businesses. He's going to talk about common immigration issues What are some of these issues? Transferring employees from a non-U.S. company to a U.S. company, directly hiring foreign nationals in the United States, establishing new offices, and dealing with the complex compliance provisions that we have to deal with in the United States. I hope you have a great rest of the day, and I look forward to having you join us on March 25th for immigration. Take care.